The law of products liability has evolved over time. Part of that evolution is demonstrated by the 1934 decision in Rotche v. Buick Motor Company. In 1929, the Buick Motor Company assembled a car at its plant in Flint, Michigan, then sold it to the Cicero Sales Company, a dealer in Chicago. In August, Cicero then sold it to Nathan Rotche. Less than a month after buying the car, but after Rotche had put 600 miles on it, he drove the car off the road, struck a culvert, and came to rest in a field. Rotche suffered injuries requiring surgery, and the car was damaged. A mechanic towed the car to a nearby automotive garage where it sat unsecured in an unlocked shed. 3 or 4 weeks later, the mechanic examined the car and found a loose brake cable. A clevis fastener and 2 cotter pins were missing from the cable assembly. Rotche sued Buick and Cicero. Rotche testified that he'd pressed the brake pedal, whereupon the car suddenly veered to the right and off the road. A former car company employee who'd examined the car in December testified regarding the loose brake cable and missing cotter pins. Buick offered evidence that all its cars underwent brake inspections during the assembly process. Buick kept records of any car found to have any missing or defective part. Buick had no record of Rotche's car having any problems. Buick employees also inspected the car in Chicago before it was delivered to Cicero. Cicero also established that, as part of preparing the car for delivery to Rotche, it had inspected and tested the brakes. After trial, the jury found for Rotche and awarded him $20,000. The appellate court affirmed the judgment, and the Illinois Supreme Court granted cert.